Come again? I told you last time you attended the meeting. What is the thing there with the court order? So I don't want any interference here.
My Lord, the issue of the adjustment of my
Somebody will tell you she attended the meeting, probably. Last time when we were here. You have forgotten when we were here, we said in-house.
Case number 335 of 2025, Uganda versus Dr. Kizza Besigye, at your way to Lutale, R/12743, Captain Obedi.
May it please this Honorable Court, I'm Thomas Jatiko, Assistant Director of Public Prosecutions. And I'm appearing together this afternoon with Richard Biri Vumbuka, Chief State Attorney. My Lord, the three accused persons are present in court. However, my Lord, the counsel representing the accused persons are all jointly and severally not present in court right now. My Lord, this matter was adjourned to today, the 13th of July. for hearing of the prosecution case as per the ruling that we received. And my lord, the prosecution is ready to proceed.
What is the witness? Said you are ready to proceed.
Yes, the witness is in the court premises.
The
Not,
witnesses are.
they are around, not inside the court here, my lord.
I'm saying here comes a sim. Capacity media.
The Vice President of the Society, we received several petitions in this matter.
You are not here.
But the first member of the faculty concerning Senior Counsel Natakaro, who has personally conducted this matter.
What I'm asking you, I put you on record, I go to the person.
You can do that and then you go to.
As the person representing them or what?
We are not represented.
Then I go there. Why is this still?
I know that I'm still on handcuffs.
Let them remove.
I came here by
Let
duress.
them first remove the. Remove the handcuffs, then he addresses the. So kindly help court on the issue of legal representation, why they are not here.
Yes.
Legal representation.
As Judge, when we were last here on the 3rd of July this year, we did address court on the challenges of our representation and that we had filed an application number 248 seeking the remedies relating to our representation. That was not responded to. And actually on the very following day, on Saturday, on Saturday the 4th, Mr. Museveni addressed the country, touching on the matters before this court. in his long address, the long and short of it that I did related to our case, is that there is indigenous community justice.
Let me first get the reason why the lawyers are not here.
I am explaining the background to that.
No, the matter was coming for hearing today.
Yes.
So tell me why the challenge you have for legal representation, why they are not here. I want to capture that.
Yes, so I'm talking about the reason fair hearing, which requires us to be represented by lawyers of our choice. But the reason I'm referring to what? Yes.
The reason is a fair hearing
Yes.
by the lawyers.
Through a representation by lawyers of our choice. And the reason I was referring to what was said on Saturday is that that belief of ours that we have a right to a fair hearing with a representation of lawyers of our choice is clear in question. Because from what
Is there anybody who has refused you that right of the choice of the lawyers?
yes, there is.
Maybe now.
And that is the subject of the application we made to this court on application 248. We were surprised that indeed, in spite of what the representations we made here on the 3rd, which included 3 main points. One,
This application is about what?
3 main points. The application is mainly about legal representation. But beyond that, I addressed you on the question of us receiving the evidence that was given to our lawyers. It was read, a letter was read in this court on the 3rd. Permitting access to us by our lawyers with the facilities to hear the disclosures. That letter was written on the 2nd of July. Which was read in this court on the 3rd.
Are you saying still there is a challenge to access the facilities?
Of course. So, up to today, we have not, because that is related to our legal representation. We we want to hear the evidence together with our lawyers. We haven't had the opportunity to do so up to today. And I made this very clear on the back.
So, kindly be specific. The challenge is legal representation. Why they are not here?
So you want to listen to the application?
So it is in that
It
application.
is in the application.
248.
Absolutely. That application was even touching on the early application 227, where we never served the respondents.
So you are saying there is
That
one
application,
thing-
you gave a ruling even before we served the correspondence, the respondents in that application. Application 248 was actually also seeking for substituted service so that we could serve the respondents in 227, in the application number 227, which now has already been ruled.
So you are saying that now there is that one pending, 248.
So there is application 248 pending. There is access to the disclosures, which we have never had. And we had also requested, the third issue we had requested, for a record of proceedings,
For which one? Because the records are meaningful.
a record of the proceedings so far
In the name.
in the main case. But in the main and in the application that we have made, and regarding that, it was even part of what was presented by Council Elias Rukwago among the 7 items that needed to be dealt with in the preliminary hearing.
So let me know those challenges you have in legal representation now. What are you requesting?
So, our request, which I made even on the third, was not responded to, is that our application 248 be heard, so that we can resolve the question of representation. Once the question of representation is resolved, we shall have access to the disclosure. Hopefully then, in that period, we shall also have had the record of proceedings, and we shall be ready for trial. Nobody wants to stay in prison. And this is why, Mr. Judge, the address of Mr. Museveni on Saturday the 4th is critical also in this case, because he addressed the nation, the whole country, on our trial. And on something totally unknown to me called the indigenous justice system.
Doctor, we need to know, let me first conclude the challenges now for commencement of the trial today. So I have seen
So the three challenges,
there is a pending application,
yes,
the record of the proceedings,
and the disclosures which follow on the representation. And these are not new demands. They have been before this court in writing and orally.
So let me get this. The disclosures which were made to your lawyers, are you saying you want also to be made to you?
They are for us. We haven't received them because we need facilities to do so. And that's what I was complaining about last time, because we make presentations to court, they are totally ignored, and matters continue as if we did not say anything. And that's why today we have said no. And we wrote a letter. Unfortunately, that letter I think also was detained by the prisons. We wrote a letter on Friday, last week, expressing further our dilemma. Having received the ruling, I think that day, saying that the hearing was to begin today. We wrote a letter on Friday. I doubt that it is yet before court. The prisons have it. So we have challenges in prison, we have challenges in court.
Can I hear for the rest? It's the same?
Well, I wanted to address you on this, the environment that has been caused now by the address of Mr. Museveni on Saturday on this case, because it is before you.
Let me first listen the challenges for hearing today and why the lawyers are not here.
And then I will come back. No
I
problem.
must resolve that.
No.
Then, President,
My Lord, for record, Captain Pettis, for your order, I want to be very brief. Most of the things have been said by everyone. But I want to talk specifically concerning myself and possibly why the lawyers are not here. The last time we were here on Thursday,
the reason why the lawyers are not here is
when we were here on Thursday, you promised to give a ruling of that day by 8. As I talked of now, I've never received any.
I've never received
A ruling of that day. And even coming to court, I was just told today by 9.
not a ruling in the application.
You promised to give
Yes.
a ruling on that day.
You didn't get a
I
copy.
did.
You didn't.
Not at all. And for today's hearing,
Yes.
they did not tell me that I was coming for hearing. They just informed me that I'm coming to court today at 9. I had no idea that court would be there today. And therefore, I have never contacted my lawyers. And I'm not sure whether they are also aware that court was supposed to be there today. So, to tell court why they are not here, I'm really not in the position. Because personally, I never knew there was a court session today. It's made clear that next time, service of such should really be done to all, so that we can prepare. But in addition, there is still also need for me to have access to the facilities, and so that I can get to understand what is in the disclosure. Thereafter, we will be ready for hearing. Thank you.
Yes, you might get to me.
But you are given a last meeting.
You still want to say,
Yes.
I don't, you go ahead. So
Yes.
the-
Is there any reason
That's the minimum.
again all these touches on the fair here? You know?
I'm giving you another chance to address court on the legal representation, which is affecting today's hearing. So that I'm able to respond.
I have addressed court regarding the legal representation.
Yes.
I want to address court regarding the statement of Mr. Muslim which touches on the fair hearing of this case.
That one, today we are not handling that. Today it is here. So let me get the challenges you have for hearing. Okay?
Precisely, this is a challenge for our hearing. Because statements that were made touch on this hearing.
That one I have captured that.
Yes, so let me tell you what they are.
No, you can't go to that address. So I need to know the challenge you have told the court.
That is a challenge. The address is a challenge. Because it's an address to the whole country. It affects the nature of this case. It influences the assessors. It influences everybody in this case, including yourself.
So I am saying that you can address me. If you have already addressed me on the challenges of legal representation.
Yes, and this is a challenge on this fair hearing before you.
I have captured that.
So I can go ahead and address you on it.
You have addressed both of the challenges of legal representation today.
Yes, I'm not addressing you further on the challenge of legal representation. I'm
Today we are
addressing
here
you.
for hearing.
I'm addressing you on what Mr. Museveni said on Saturday the 4th, which has
The
strong.
issue before court to resolve is legal representation in China. Okay?
So when do I raise this?
You said there is application. You want me to listen to the application in court? You said there is a pending application.
Yes.
You want to argue to now?
The pending application is on the representation.
And that's what we are handling now. So what you are saying, we cannot go to the merit of that case. But today let us handle why we cannot go.
I don't know whether you have received the letter we wrote on Friday to this court, because it also contained some of these matters.
We also wrote a letter.
Yes, which is with the prisons authorities. And they are here, maybe they can confirm whether they have brought it or haven't.
About the same.
Yes, about these issues. You want to put it on record?
So that one, so that they allow the people to respond.
So the letter has been received.
I will go and report to you. I will go and just a minute. Prison. Can I know the letter? Was it what did you provide?
Yes, my lord.
What was it?
My lord, I'm Assistant Superintendent for Prisons.
Assistant?
Superintendent for Prison. For the letter in question,
Can you?
I'm Assistant Superintendent for Prisons, Hero Emmanuel. Hero Emmanuel.
Yes, about the letter?
My lord, all article is written to go through a verification process before they are forwarded. All articles written by the accused, they undergo a verification
Is this
process.
for what the law is still undergoing? That's what
I need to confirm the status of the said letter.
So I'm not sure who is this.
Yes, my lord.
Okay, let the state reply because this is.
I forgot to mention, excuse me, I forgot to mention, Mayor, that we have also filed a notice to appeal your ruling. Appeal the ruling in our application for this. And we again need the record of proceedings to proceed with that appeal.
So you are not so appeal in which ruling?
In the ruling of application number 227. That is the human rights enforcement application.
Okay. It's noted. So state.
For record, my lord, Richard Billy Vonbuka, Chief Secretary. For prosecution. My lord, in response to the issue of representation, the accused persons maybe to start with A1 and A2. I think that's why it is more contentious. Are represented by more than 35 lawyers. A1 and A2 are represented by more than 25 advocates. And they have been on record since this matter, my lord, moved from the Chief Magistrate's Court, Nakawa, to this Honorable Court. My lord, would appreciate the right of the accused persons, legal representation, and more so by advocates of their choice. As envisaged under Article 28 of the Constitution, and Section 56 of the Trial on Indictments Act. Because it constitutes part of the fair hearing. My lord, since the last sitting, A1 and A2 have been unrepresented. Unrepresented. And in his submission, that is our senior citizen and great statesman, Dr. Kizza, A1, he submitted that the lawyers were not in court because Senior Counsel Martha Karua, last time, even last time, yes, my lord. Yes, I'm bringing my thing properly, my lord. I'm rebutting it, my lord, because without that I can't make my point. He argued that they were not in court simply because Martha Karua and
starting from.
Yes, my lord.
I didn't hear him talk about Massa and others. We first help both to address the concerns, their concerns today, why this...
My lord, it's going to help you in this matter very well.
No,
because I'm not going to do very much.
About his,
okay, my lord. My lord, we have never received any notice we have never received any notice of withdrawal of instructions from any of these lawyers. And actually, even the accused persons, that is A1 and A2, have equally not informed this court that he withdrew instructions from all the lawyers who are representing him since this matter started. So the assumption is that the instructions are still active. So therefore, when the accused person appears in court unrepresented the way he did last time, it's becoming habitual. And my lord, it is either unexpressed or implied notice to this court that they have waived their right to legal representation of lawyers of their choice. And my lord, this act is frustrating the hearing of this matter, because the principle of fair hearing, or the issue concerning hearing, is not only about the accused persons. It is about the accused persons and other parties that are involved, including the public. My lord, ever since we did our last disclosure, which I think a month or plus ago, prosecution has been ready to have this matter heard. But we have been arm-twisted, always. And there has been a picture that has been painted to look as if prosecution is the one frustrating the trial or the hearing of this matter. we want to make it categorically clear that we have been ready to have the accused persons tried. Today we have witnesses and we came ready to have the matter heard. My Lord, this in effect constitutes an abuse of the legal process. But my Lord, if the accused persons are abusing the process, this court, my Lord, has tools at its disposal under Section 17 of the Judicature Act. To make a finding, my Lord, among others, that the accused persons have waived the right to legal representation of their choice. My Lord, Section 17. My Lord, Section 17(2). With regard to, says, with regard to its own procedures and those of the magistrates' courts, the High Court shall exercise its inherent powers. A. To prevent abuse of process of the court by curtailing delays in trials My Lord? Okay, most obliged, my Lord. So, my Lord, I will submit that this court can make a ruling, a finding, based on that provision, that the accused persons have given up. They have waived that right to legal representation of their choice. The assumption, my Lord, here is that under those circumstances, it becomes a voluntary waiver where most obliged, my Lord. And my Lord, the court, in doing so, it can direct the matter to proceed for hearing. And in alternative, court can appoint lawyers on state brief to represent the accused person. And my Lord, it is our prayer that court makes a ruling to ensure that we try, we have the matter tried. We are ready. Because if it doesn't, it's going to create anxiety in the mind of our witnesses. And some of them may end up not testifying. My Lord, as prosecutors or DPP, we are not party to application number 248 of 2026. We are not privy to it, and we are not aware of its contents. And my Lord, we are also equally not aware of the effects of the speech of the President in regard to this matter. My Lord, this court is independent and as per the Constitution, and this matter will be tried best
Are you responding
on
to
the
what
facts,
you didn't say?
on the facts, evidence and the law.
He's saying
You wasn't allowed to say what you
didn't address that matter.
Most obliged, most obliged, my Lord. Most obliged, my Lord. Most obliged, my Lord. But he hinted about it, my Lord.
Yeah, but I said it is not here, so you
Most
can't.
obliged. My Lord, we so submit.
Yes,
an opportunity to respond in the brainer of what.
Yes, very briefly, Mr. Judge. The application for it was filed last month. It was raised to the attention of this court on the 30th of June, when we came here to this court. This is also a human rights enforcement application. That we expected would be dealt with as a priority. If it had been dealt with, we would not have been in the dilemma we were on the 3rd. We would have resolved the issue of representation. It was not attended to in the hearing of 30th. It was not attended to in the hearing of the 3rd, in spite of raising it in both appearances. circumstances that propelled that application were not of our own making. They were the making of the state. Which kidnapped Councillor Okuwulira and tortured him. And which arrested and deported Councillor Martha Karua. These were the actions of the state. Illegal actions of the state. If they hadn't been there, there would be no application 248. You would have proceeded normally. The details and the evidence in that application can only be dealt with by hearing the application. And if it's business, dismissing it. Regarding the lawyers not notifying prosecution, regarding their lack of instructions, that would be a matter for the lawyers to deal with. It cannot be visited on us. But suffice to say that both on the 1st of July and on the 3rd of July, in this open court, we did on the 30th of June, and on the 3rd of July. In this open court, we did put on record the situation of our representation. In their presence.
So, Doctor, this challenge, how long, according to how long can we wait on this debate?
If 248 can be had tomorrow and resolved, then the following day we will have a way forward. It hasn't been had since we filed it last month and talked about it in these subsequent appearances. Again, not for emphasis, since it seems Chief State Attorney Benbomuka didn't get it. The disclosures were made to our lawyers. For us to receive them, we need the facilities through the prisons authorities for the lawyers to now make us access them. trial, and indeed they said they had a witness here on the 11th. They had a witness in court. But on the 3rd of July, they themselves read a letter that was now, for the first time, allowing access to facilities, which was written by the prisons authorities on the 29th of June. So we are supposed to hear evidence on the 11th, long before prisons considered to allow facilities to access the disclosures. By the 2nd of July, when that letter came to our notice, and I'm sure to their notice, the crisis of the lawyers had already emerged. So we have no way of accessing them since July the 2nd, when that letter was written. And until the resolution of the legal representation which we are seeking. Regarding what he describes as abuse of process, then I think there must be completely different understanding of the judicial system, the legal and the judicial system we are following. Mr. Billy must be following the indigenous communities judicial system, while we are following the colonial or neo-colonial judicial system, whereas Mr. Museveni said includes the judges who are actors with wigs. Mr. Judge, the absence of our lawyers was occasioned by the state itself, not by ourselves. And it is the state that has progressively abused the process. It was the state which which took us to the defunct military court-martial, military tribunal, which had long been declared unconstitutional. The state, the guarantor of the Constitution, nonetheless took us there and charged us in an unconstitutional court, where we spent months. This court ordered for disclosures last year in December to be concluded by January. In a matter where all investigations were complete in May of last year. Yet from December, disclosures were completed in June. Our lawyers begging for sanctions against the state. Every appearance, we wanted the court to sanction the state for not following court orders. Which is the same state saying we are the ones abusing the process. Therefore, constitutional rights must be stripped. So, I beg this court to hear our application to resolve the issue of our lawyers. And once resolved, allow us access, allow us time to access disclosures, and also to give us the record of proceedings. And we shall be ready to face their witnesses. As I ask for, see that. Maybe what I forgot, you also talked about other parties which are inconvenienced by delays, saying we are looking at our own situation, not the situation of the other parties. The party, and this is a matter which you also touched on in your ruling on the human rights enforcement application. That those who apply for human rights enforcement seek rights of the victims. Our trial is of the nature that, because we are chosen of treason, actions against the state. So the aggrieved party is the state. And it is the aggrieved party violating human rights in this case. Coming with gripping hands to seek justice. So, I wish to reiterate that our applications cannot be an abuse of the process, cannot injure the other party, because it is the other party that is injuring us. So,
for the past machines.
This is the ruling of this honorable court. I have very carefully listened to the concerns from the chosen persons and the prosecution. The concerns and the reply from the prosecution, I will court record, I will not reproduce it. And for the interest of time, I will give a summary of my ruling, and I will avail to you a detailed one later. But briefly, the issue before this honorable court is the issue of legal representation. Today, the matter is coming for hearing. The prosecution told the court that they have witnesses around the court. The prosecution said that they were ready to proceed. However, the chosen persons, specifically A1, raised some concerns. In briefly, the concerns that affect the legal representation. To be specific, the concerns he raised is that, one, that there is a pending application number 248 of 2026, which is still pending before this honorable court and is related the issues of legal representation. According to the chosen persons, that is A1 and A2, they told the court that this application should be disposed of first. I will come back to that. They also raised the issue, the chosen persons, of the disclosure. The person said that the disclosure was made to their lawyers, who have since got the challenge. And for them, they have not received the disclosure. I will also come back at it. The accused persons also informed the court that they want to be availed with the record of proceedings in this case and the applications, which also come back. Another issue of concern was that the facilities in prison, which prison wrote this honorable court as of the 29th June, that the same be availed to the truth and their team. Another concern is by S3, who raised the issue that he was not given a copy of the ruling in his bail application. Briefly, I will now proceed to make the following remarks and findings on those summaries of the concerns raised by the chosen persons. One, I am very well aware and alive of Article 28 of the 1995 Constitution. Briefly, Article 28 provides for the right to a fair hearing. I will go ahead to Article 28.1. Article 28.1 provides that in the determination of civil rights and obligations for any criminal charge, the person shall be entitled to a fair, speedy, and public hearing before an independent and impartial court or tribunal established by law. I have also considered Article 28(3)(d) of the 1995 Constitution. It provides that is 3D, that every person who is charged with a criminal offense shall be permitted to appear before the court in person or at that person's own expense by a lawyer of his or her choice. Indeed, from the time we started this case, the two persons were permitted the lawyer to the services of the lawyers of their own choice. Not until 30th June and specifically 3rd July, when the lawyers of their own choice that had been representing them were not present in court. I will now go to Article 28(3)(e). Article 28(3)(e) of the 1995 Constitution provides that, I quote, in the case of any offense which carries sentence of death or imprisonment for life, the accused is entitled to a legal representation at the expense of the state. In this instant case, and specifically the concerns raised by the chosen persons, I will address all their concerns one by one for the interest of justice. Concern 1, that is mere supplication number 248 of 2026, which is allegedly to be pending before this honorable court, or specifically before me. Cases normally are allocated to the judges. Judges don't allocate cases to themselves. I want to make it clear that from my knowledge, serious application number 248 of 2026, which the accused persons are talking about, has never been allocated to me as a judge. It's not before me. But the registrar can find out from the registrar who allocates cases. But the said application has never been allocated to me, and the same application I cannot use it or debate it to hold this trial, because it is not until that the same application is allocated to me that I would know the content. But at this stage, I don't know the content of that application, which has never been allocated to me, that I can form a mind to hold this trial in session number 335 of 2025. I will go to the issue of disclosure. The accused persons have told the court that the disclosure was made to their lawyers. True, from court record, the final and full disclosure was made on the 1st of June 2026. And I would take what the accused persons have told me, that they have never received such a disclosure since the disclosure was received by the lawyers who have since got challenges. I now order and direct the prosecution that for the interest of justice, at the end of this sitting, I'm ordering you make avail all the disclosure that to the persons before court here on their own, since the other one, according to them, was made their lawyers. So at the end of the sitting, prisons kindly hold on around the prosecution to avail all the evidence they intend to use in this case, avail it to the accused persons themselves. In case there is any challenge of the prosecution to do that, serve all the evidence they got rely on today, of which I believe, and I told court that they were available as witnesses, I guess they had that evidence they intended to use, so avail it to the accused persons themselves. On the issue of proceedings, in this case, and in other applications, I'm directing the Registrar of Criminal Division to avail the copies. In any case, the proceedings are by transcribing. So the IT should help the registrar to have these proceedings in this main case and applications, so that the registrar can certify them and serve the accused persons. This one can be done by tomorrow, which is 14th. And let the registrar, the IT, together with Zira prison, they should get these proceedings and avail them to the accused persons. I will now proceed to the facilities in Zira. As the accused persons and specifically A1 40, it is on record that at least by 29th June, the Zira people wrote this honorable report, and the letter is in record, that they had granted almost several facilities to the accused persons and their legal team, and directing Zira to adhere to the same. I want also to go ahead and comment on the ruling for S3, that it was unfortunate that you have not received the copy of the ruling. Yet this court directed the registrar and the Zira people to avail you with this ruling. I will now again direct the registrar and the Zira people, even the Zira people before you go, make sure that you find out where it is, whether the registrar or the Zira, so that S3 is able to get his copy. For the interest of justice, and specifically to address the issue of legal representation, the chosen persons have been represented by lawyers of their choice as per Article 28, 3D, from the time we started this case, at the time of the pre-taking. However, it is my considered view that the chosen persons were permitted to have lawyers of their choice from day one. But since this court keeps getting concerns from the accused persons that they have challenges with their legal representation, specifically lawyers of their own choice, this honorable court will move to look at the relevant laws. In the case such a challenge keeps on, because my view is that there must be a solution for the trial to commence, and I am aware and alive of the right to the fair hearing. And my view, this case has suffered several delays, and indeed the accused persons have said they have been in remand for some time. So this honorable court has decided to invoke Article 28(3)(e), which provides that the accused persons are entitled to legal representation at the expense of the state in the cases of any offense which carries a sentence of death or imprisonment, life imprisonment. In the view of the above, the registrar criminal division is directed to avail